Trustee who shall fail or refuse to perform duties required by this act shall be deemed guilty of a misdemeanor, and upon conviction thereof shall be fined any sum not exceeding $100. The statute, it seems that my secretary omitted that pertaining to township trustees, but there is a provision that if the owner fails to do so, then upon notification by any peace officer, the township trustee must go out and do that, and provides a penalty if he fails to do so. Another section provides that any owner, lessee, agent, or tenant who shall refuse access to lands or obstruct or interfere with the township trustee or any personnel arranged for or by him in pursuance of provisions of this act and his efforts to destroy or eradicate such marijuana weeds as provided for in this act shall be guilty of misdemeanor, and on conviction shall be fined any sum not exceeding $100. The 1955 legislature passed a law making it a misdemeanor to disobey provisions of law in respect to barbiturates and similar drugs. There's a word omitted. I haven't the slightest idea what it could have been. A defense based on the use of drugs is subject to the same rules as the defense of intoxication. The use of drugs is not a defense unless it causes mental derangement which meets the test of insanity. The leading case on the test for insanity is the right and wrong test. Probably you've heard of this. It was set forth in the House of Lords in the McNaughton case in 1843. This opinion states, and I quote, "To establish a defense on the ground of insanity, it must be clearly proved that, at the time of committing the act, the party accused was laboring under a defective reason from disease of mind, as not to know the nature and quality of the act he was doing, or if he did know it, that he did not know what he was doing was wrong." End of quote. To this test we have later added, due to the fact that it didn't cover all situations, the irresistible impulse test. And this test holds that the right and wrong test is not sufficient in all cases, and that a person who knows that the act he was committing was both morally and legally wrong may still not be held responsible if he lacked the power to resist the impulse to commit it. This test was adopted in Indiana in the case of Morgan versus State, 190 Indiana 411, also in 130 Northeastern, page 528. The fact that a drug user is a drug addict is not conclusive that he is of unsound mind. So that when the tests are applied and the court instructs a jury of the McNaughton rule and of the irresistible impulse test, they cannot, just as a matter of law, because a person is an addict, find him not guilty. They must also go farther than that and find that the use has caused him to be of unsound mind, at least at the time of the act in question. Many crimes against nature and crimes involving the larceny of property are committed annually by the users of drugs. The crimes against persons are a result of uncontrolled passions, the lowering of moral and legal inhibitions, and the desire to consummate the drives and instincts. The crimes against property are usually the nature of theft and larceny, to obtain money or property or other thing of value which can be used, sold, traded, or bartered for narcotics. Much of our law pertaining to the use of drugs comes out of this area, much like the motor vehicle operator under the use of intoxicants and drugs. Speaking of motor vehicle operators, just a little sideline. A young fellow went up to the license bureau to apply for a license, and on the application he was told that he must answer every question. One question was, "Have you ever been arrested?" He answered no, and thinking he had to answer the next one under the question, "Why?" "Never been caught." And this is generally true of most of them. Testimony by witnesses, for instance, that the accused at and immediately after the crime was under the influence of drugs is competent. But testimony of a non-expert witness as to the effect of a drug upon the accused is incompetent. Now, there are certain areas of law where a person not a witness to a crime can testify, and in these areas we call those people expert witnesses, and they may, by having a knowledge of the field far superior to the average person, testify as an expert witness. But a non-expert witness may not testify to the effect of a drug upon a person. A habitual user of opium, though he is not a chemist, is a competent witness on the identification of the drug. In other words, a person who uses it is a competent witness for identification. And again, in the rules of evidence, there are so many rules and so many exceptions that it really is a problem at times to try a case of this nature because there are more exceptions than there are rules, and it makes it a difficult thing to do. The use of drug, to the extent that it renders the user unconscious, brings on another area of the law. The defense of unconsciousness is not the same as the defense of insanity. Unconsciousness goes to intent, and ordinarily an unconscious person cannot be held criminally responsible, but if a person who knows he is subject to frequent blackouts, natural or induced by drugs, uses a dangerous instrumentality, such as an auto, and hurts someone, he may be guilty of criminal negligence. In other words, generally speaking, a person who blacks out, commits some act from the use of drugs and is unconscious cannot be guilty because he cannot formulate and entertain a intent to do the act. But if he knows that he is subject to this, in other words, he's had the experience before of blacking out and uses narcotics or even alcoholic beverages and blacks out and has an accident and kills someone, then he may be found guilty of criminal negligence. Courts also take judicial notice of certain facts pertaining to narcotics. Judicial notice is notice taken by a court with the production of evidence of facts which are within the common knowledge and experience. Therefore, judicial notice will be taken that certain narcotics, when inhaled, produce sleep or death, that opium is not commercially a domestic drug, and that morphine is a derivative of opium. The court judicially knows that opium users need to keep their nerves stimulated, and that a drug victim desires to quit using such drug, but is powerless to resist the habit. Judicial notice is also taken of the fact that illicit drug vendors make great profits. So that is just a few of the sidelines that I picked up in research of things that the courts do take judicial notice of. In the prosecution of crimes generally, and more specifically in those crimes requiring proof of intent where the defense is insanity and there is sufficient evidence thereof on which to base instructions, as where there is sufficient evidence to raise a reasonable doubt as to the accused's guilt on the ground of insanity, the court should instruct as to the law of such defense as applied to the facts of the case, even though the only testimony concerning the facts of the insanity may come from the mouth of the accused. In other words, ordinarily there is a rule against self-serving statements made by a defendant in court, but this again is one of the exceptions, that a defendant may get on the stand and testify to facts that has transpired which would put a defense of insanity before the jury, even though he is the only person who knows of those facts. It is error for the court to ignore and exclude such a defense. The Supreme Court has so held. It has been held to authorize an instruction on insanity, there must be some evidence of a diseased mind or something more than a violent, uncontrollable desire to kill. This was set out in 275 Kentucky 208 and again in 225 Kentucky 492. It has been further held that where accused was insane from the use of drugs, the court must charge thereon, even though a charge on the general issue of insanity has been given. In other words, if there is a plea of insanity, we usually give a general charge or instruction to the jury. And again, I don't know whether all of you have been in court or not, but at the end of every criminal case, we must give an instruction of all the law that might apply to the case, even anything that might remotely apply to it, because we can't take away from the jury any question that could be entertained by them. In a civil case, the law is set out by the court, and the jury finds the facts and applies the law as set out by the court. In a criminal case, the jury finds what the law is and what the fact is and apply them themselves. The court only advises. So we have to advise them fully in a criminal matter and let them know what the law might be on every area that there is testimony on, even though we as judges might not quite see the application of such instruction. Persons who are detained in prison otherwise than on conviction of crime, as persons detained for default of surety for good behavior, or to keep the peace, or idiots, insane persons, and inebriates, so detained may not be required to perform labor, not even defray the cost of their keep. But this is rather interesting. And a person who is an alcoholic or a narcotic addict cannot be required to perform any labor at all while they're in an institution for their treatment. A statute is not unconstitutional, however, which authorizes detention or imprisonment of persons acquitted of crime on the general ground of insanity, or the specific ground of insanity induced by narcotics. Now, there is a difference there. The first instance I was talking about a person who was civilly committed for treatment. You may not require them to work, to do anything. But a person who has been found not guilty of a crime by reason of insanity and committed as an insane person may be detained as any other person is detained. Now, we commit every day people for alcoholism, not involuntarily though. You cannot commit anyone for alcoholism or narcotic addiction to any institution without them asking to be committed. In Indiana, we have what we call Section 213. My area is Richmond. That's where I commit all people who are insane. And there was a time we used to commit some to Norman Beatty, Dr. Norman Beatty Hospital at Westville, Indiana, who were criminally insane, but now we have to commit by law to the Division of Mental Health, and they assign the people to a hospital, and so most of them go to Richmond, Indiana, and I wonder about the wisdom of that sometimes, because we get some really violently criminally insane people, and they're sent down to Richmond who does not have detention facilities, and so I wonder where we're going in some of these fields, but that's neither here nor there. We may not commit anyone for alcoholism who is not asking for it. It must be voluntary. Now, once in a while, and it applies the same in narcotics, drugs, if a person has used drugs or drank to such an extent that it has diseased his mind and has become insane, then he can be forcibly committed for treatment. And this is frequently done because when we get people in who are users to the extent that they have tremors and hallucinations and all of those things, then they are within the medically, at least the legal medical definition of being insane people, and we do commit them for treatment. It happened. How much time do I have? 5 minutes. No, I have to rush along here. It has been held that a person admitted to a federal narcotics farm for the purpose of receiving treatment for addiction to the use of narcotic drugs after contracting to submit to confinement for a period estimated by the Surgeon General to be necessary to effect a cure, or until he ceased to be an addict, could not be involuntarily detained, notwithstanding the period estimated by the Surgeon General, for a cure had not expired and petitioner was still an addict. In other words, when you go to an institution for treatment for addiction for a period of time and you sign for it, if you take a notion to leave, they've got to let you go. And this was set out in Ex parte Lloyd District Court of Kentucky, 13 Federal Supplement, page 1005. Temporary insanity resulting from the voluntary non-medical use of drugs constitutes no defense to a criminal charge except as it may bear to the capacity to entertain a requisite specific intent. Although settled insanity or pathological addiction may afford a complete defense, if a person becomes temporarily insane through the voluntary or moderate use of morphine or other drugs not taken as a medicine, his responsibility would clearly be that of a person drunk from the voluntary use of alcoholic beverages, and has been so held. But if mania or insanity is fixed and permanent in character, so as to destroy the knowledge of right and wrong as to the act, the person laboring under such infirmity will not be held responsible. Where specific intent is required, the mind of the accused must not be so affected by the use of drugs that he did not have the capacity to formulate and entertain the requisite intent. This was set out in People versus Nom Dum Dong, 26 California Appellate, 2nd, 135, Strickland versus State, 137, Georgia, 115, and Prather versus Commonwealth, 215, Kentucky, 714. Generally speaking, that about covers a wide area of the law as far as narcotic addiction. I know that the field is so great, I've skipped around all over here and hit a little here and a little there. It'd take hours to present anyways near the law pertaining to all aspects of it. So at the question and answer period later, I'll be happy to try to answer anything that you may wish to offer. Thank you.
Judge Cox is comment about the expert witness. Now, do I take that to mean what I consider a person that's turned state witness and you use them in your court? And, well,
you mentioned, do I understand, are you asking, is this the same thing as a state's witness?
Yeah.
Not at all. You can have an expert witness on either side. For instance, if there's an application for commitment for insanity, normally well, in a case of criminal insanity, the court appoints two competent physicians who examines the accused and makes a report back in writing to the court, comes to court and testifies for, and usually on behalf of the state. But on the other hand, the defendant may obtain a psychiatrist, if he so desires, to testify on his behalf, and he testifies as an expert.
Well, thank you. Let me enlarge on this. What I'm referring to is a person who was involved in the narcotics traffic, who was cornered and turned state witness to protect himself. How does the law legally protect this person? In other words, he's a known pusher, he's cornered, and he turns state witness, and
well, usually when he turns state witness, so to speak, and this would be true of whatever crime it might be, it wouldn't make any difference whether it was narcotic use or whatever. When a person turns state evidence, he makes a deal with the prosecutor that in return for his testimony, he will not be prosecuted. And the law is in Indiana. I don't quite go along with it at all times, but a prosecutor may not be compelled by anyone, not even a court, to prosecute any person. And if he makes this deal and sticks with it, there is nothing anyone can do about it. Not even the Attorney General of Indiana can come down in Delaware County and say to prosecutor, you must charge this person with a crime and prosecute him. No one can do this. Prosecutor is a little king in his own bailiwick and can do as he pleases. The only way a person could be charged with a crime other than by the prosecutor would be if the grand jury was in session. They can take cognizance of any matter that they want to, can prosecute any or return an indictment. But again, the defect in this is that even though the grand jury may return an indictment, the prosecutor is still the person who has to prosecute it. And if he sits on his hands, well, this is the end of it.
I understand. Thank you. One more, please. Recently I read where our so-called free press and the newspapers supposedly were to have some kind of censorship, maybe by the courts. Is this going to be true in the narcotics business? By that I mean we're going to plan a raid, say in Anderson, and we take the newspaper reporter along, which maybe is okay. I wonder how free we are with the news media in the narcotics investigation and also in your courts. Is there any limit to that?
Well, as far as the court's concerned, we don't censor newspapers at all. A newspaper can write anything it wants to. The only area that I am aware of that you might be talking about is that in capital cases involving usually homicide or something of that nature, where there is undue publicity of it, sometimes the defendant claims that he can't get a fair trial in the county and takes a change of venue, which makes a hardship on the county. Lots of times we'll spend $30,000 or $40,000 on a case outside the county, which we could have tried in the county at very little cost. And this is the only area, like the Ruby case down in Texas. There was so much publicity given to that it caused all manners of trouble in trial of the case. And this is the only thing that I know that you could be talking about, but we don't censure anyone. Newspapers, TV, reporters, and anyone can come into court and report the news as far as I know, or report the things that are a matter of public record. Your arrest sheets and all those things are a matter of public record. They can, yes?
Well, this also applies, Judge, to the narcotics rate itself. In other words, we raise this establishment, but we take the newspaper reporter along so we get the good story. This is what I'm referring to.
Can it be censored?
No, how does the person react to this? Is this perfectly legal?
Oh, certainly. That's what I don't care what the newspapers do in the way of reporting news, which is a matter of common knowledge. And anything that is not privileged or is not confidential, as far as I'm concerned, can be reported. It does create problems in the trial and in getting a fair and impartial jury at times. And this is our real problem and our only problem. As far as the court's point of view, is getting a fair and impartial jury and getting a fair trial for the accused. This is the only thing that we really worry about. Yes, ma'am.
You mentioned that possession is unlawful even though the person didn't know that he possessed this drug. Does this mean that a physician can write you a prescription, you can get it filled and use it, and not knowing what was in it, you store it in your medicine cabinet? You can be prosecuted if it is found in your medicine cabinet?
You could be, yes, under the statutes. Very definitely so.
But the physician does not have to inform you of what is in the drug he is prescribing for you.
Unfortunately, as I understand it, most of them do not. They should, however, inform every person that they are giving them a drug, because it does, unless they have it on hand for imminent personal use, it is forbidden under the statute, and technically it constitutes a violation of the law and a crime.
One more question. Are there any laws pertaining to the use of deliriants such as glue or sniffing other solvents? Are there any laws that pertain to this?
Not to my knowledge. If there are, it's escaped my attention. Now, we do in juvenile court charge children with being delinquent children who do this. But as far as I know, if any, it could come under the Poisons Act. I'm not sure. I hadn't really thought about it because I hadn't had a case on it. You know, we only know the law. There's an old saying, you know, in law school that let's see, how is it? The law teacher knows all the law. The attorney knows some of it, and he tells it to the judge who doesn't know any.
Judge Cox?
Yes.
Is a druggist legally bound to fulfill a prescription of any physician even though he may suspect it's being used illegally?
I would imagine so.
The druggist is bound legally to fill a prescription.
Otherwise he would be, to say this properly, I suppose he would be substituting his opinion for that of the physician that the person did not need it. And medically he can't do that. That would be practice of medicine.
And one more question. You spoke of the cases where a physician also owns a drugstore, runs a drugstore. Then he can write his own prescriptions and fill them legally, or can he only...
He could not do so unless this is a regular patient.
He cannot...
that would be my thinking under all... I've read 3 or 4 cases on the subject, and he can't wear the 2 cloaks and act as such except with people and with whom he is dealing in a good faith doctor-patient relationship.
Okay.
Lady here has a question.
What do you think of the insanity plea? Is it not misused?
Insanity? Well, I can't say that as a matter of inclusion of law or fact, either one, because what is insanity, you know? How far off do you have to be insane? This is a real question.
My thinking is that if they say they were under the influence of drugs and they murdered someone, they pleaded insanity. Well, no one forced them or told them to take the drug. This is why I wonder, how can they use this insanity plea?
Well, it is this is a question of fact always for the jury as to whether the person is legitimately using it or whether they were actually laboring under insanity. But what I meant by the offhand remark I gave at the beginning there, in my opinion, from my standpoint, anyone who uses it is insane. You know, there'd have to be something wrong with them, because I know I've been to some of those places when I was in law school where there were a lot of those addicts, and to see the human wrecks, if anyone has seen it, they won't use it, because it's the easiest thing in the world to become addicted to, as far as I know. And once addicted to it, it's the hardest thing to break. And so anyone of any knowledge, education, or even observation of human affairs would have to be just a little bit off to use it in the beginning. I mean, this is not a legal answer, it's just my personal view.
Judge Cox, like under the Harrison law, most of the drugs which are referred to here, except for the cocaine, are the narcotics or are, depressants. Now, what laws is it that govern the use of your stimulants, such as your things to keep you awake, and the abuse of these drugs, or like, say, someone using nutmeg or something like this? How is this held by the law?
You mean like the barbiturates and things like that?
Yes.
The Uniform Drug Act controls that.
Now, does this state that they have to have a prescription to get this, or what about these that they don't have a prescription, which
Well, there are certain standards set out by the, I don't have the standards with me, I don't believe, set out by the state and by the federal government and the formulary and the codes that they have, and this would control the amount, and I don't know what the specific amounts are. So I can't truthfully answer your question there as to what barbiturates could be sold and what could not be.
Well, what I was wondering, say a person would, it's not necessarily illegal to buy some of these drugs,
That's true. This is right.
across the counter. So
Right.
what does the law state about the person who takes this drug that's not illegal to buy it, and then you might say abuses
If
it,
it's legal to buy it, it's legal to have it, it's legal to use it,
and to abuse it?
and to abuse it, yes.
Okay, this is what I...
Right.
Okay.
Only the prohibited drugs, I maybe didn't make myself clear, but only those prohibited by law can be prosecuted for possession, use, sale, manufacture, compounding, or whatever.
What does the law state pertaining to the growth in an ornamental flower garden of poppies from which opium could be derived?
Unless you had a license for it, a duly licensed under the Act, it would be forbidden. And even then, you'd have to be growing it for some legitimate use, such as research, sale to a legitimate firm, or something like that under a license.
What are the legal penalties for the possession or use of the narcotics or marijuana or LSD in Indiana today?
Again, what was that?
What are the legal penalties for the possession or the use of, well, let's take it in three categories: narcotics, marijuana, and LSD.
Very minimal. It's unfortunately they're low. I think about $100, I think, is the maximum. And no, it's $1,000 and 1 to 10 years, which in my opinion is rather low. You don't agree with that?
Well, no, we had a speaker the other day that mentioned the risk that the example he used was the athlete who ruined his ankles by, running and playing football for 4 years of college. Could get into medical school, etc., but not reach the goal that he wanted to, and yet a person who would just use marijuana once and was caught, had a criminal record or some kind of record, and could not be admitted to many occupations that this person might desire. How do you feel along these lines? Do you think that just the use of it once is
actually, every case is on its own footing, and the maximum, you asked how much, and I was referring to a maximum. Such person may also be imprisoned in the county jail or state penal farm for any determinate period not exceeding 1 year and fined any sum not exceeding $500. The court takes into consideration the nature of the offense, what was done or should, and of course the reason you get different penalties is because of different judges in different areas and different laws and things like that. But it should be uniformly administered, and actually, I suppose a person that uses it once shouldn't be penalized as much as a pusher or someone who deals in narcotic traffic and things like that. But again, every case stands on its own footing. And again, as far as the question asked by the young lady a while ago about insanity, again, the defense of insanity is another thing. Every case is different. And this is a question of fact and law to be decided, whether the person was insane at the time or in your question there, the severity of the penalty should take into consideration the nature of the offense. And if it doesn't, then it isn't really a fair administration of law, or application law, rather. But now, a second offender can be fined as much as $3,000 and 2 to 15 years in prison. So a second offense is dealt with more severely. And of course, each offense thereafter is greater.
Thank you very much, Judge Cox. We'll stand in recess for 10 minutes. I'd like to see Mr. Beckstein and Ms. Brett.
Good morning, ladies and gentlemen. This is a new experience for me. I'm lecturing to a college graduate class. I did have the advantage of, I suppose, putting on a TV program 5 years before I helped Dr. Bach in this project of his some 2 years ago. So talking to a microphone, or rather to a TV camera, is far more natural to me than talking to people in person. You know, as a judge, you don't say anything. You sit and listen, and this is what I do best, is sit and listen to people. And so this is a new role, really. I suppose, in speaking of the regulation and control of drugs as far as the legal standpoint, I don't know how much you people know about courts, but generally speaking, the law is divided into 2 basic sections, criminal and civil. Civil law arises out of a situation between one person and another. Criminal law situations arise out of an act or offense against the peace and dignity of the state or the Commonwealth, whichever it may be. Therefore, the government is always the plaintiff in a situation like that. So, with that basic approach, I suppose, we can go into the aspect of the criminal law and the drug problem. In the regulation and control of drugs, the federal government has, under the Federal Food, Drug, and Cosmetic Act, provided that the term drug means articles recognized in the official United States pharmacopoeia, homeopathic pharmacopoeia of the United States, or any official national formulary, or any supplement to any of them, articles intended for use in the diagnosis, cure, mitigation, treatment, or prevention of disease in man or other animals, articles other than food intended to affect the structure or any function of the body of man or other animals, and articles intended for use as a component of any article specified in the above clauses. But the term drug does not include devices or their components, parts, or accessories. And this is found in the 21st volume of the United States Code, Article 321, under Section G. Incidentally, this morning in making this presentation, I had included in my speech content a number of real good jokes about drugs and things like that we usually tell. You know, lawyers and judges are the best joke tellers there is, and since this is being recorded, we'll omit those. And maybe privately sometime I can tell you a little something about drugs and dopes and illegitimates and all those things. As generally defined, a narcotic is any substance which directly induces sleep, allays sensibility, and blunts the senses, and which, when taken in large quantities, produces narcotism or complete insensibility. And this was defined in People versus Lee Foon, 250 Appellate Division, 616, New York State. Incidentally, when I refer to these things in the way of legal precedent, these things are what we call precedent-setting cases that most states follow in the interpretation of laws. In the enforcement of law, there are no crimes which are not defined by statute. And unless they are defined so that everyone may know what the crime may be, there can be no crime. So, as we interpret statutes, the courts do, we follow precedent-setting cases, and these that I will refer to are what we know generally as precedent-setting cases. A druggist is essentially a dealer in drugs. This is simply put in Stolen Work versus State, 116, Alabama Appellate 214. Incidentally, at times, the legal definition and medical definition is entirely different. And we have the last word. To fill a prescription is to furnish, prepare, and combine the requisite materials in due proportions as prescribed. A prescription need not be for human beings only, but may apply to medication for animals. And this is set out in Ray versus Burbank, 61 Georgia 505. There's no saying that what we say as the law is put down in writing, and if we make a mistake, our mistakes are open to public and we must face them. If the physician makes a mistake, he buries his. A poison is any substance which, when applied to the body or introduced into the system without acting mechanically but by its own inherent qualities, is capable of destroying life. People versus Vanderleer, 53 California, 147. In the regulation of the use of drugs, the practice of pharmacy is a legitimate field for legislation for the purpose of control by the state, provided such legislation does not conflict with that of the federal government. Incidentally, I suppose some of you have had some courses which set out this theory, but just basically, any power granted to the federal government, the state may not legislate in that field, at least to the exclusion of the federal. If it conflicts with the federal government, then the federal law controls. And this is one area, the field of narcotics, in which the federal government has exclusive control if they wish to preempt it, because all narcotics are, well, basically, in the beginning, they were under the Department of Commerce because of interstate commerce, and this is, in the beginning, most of them were imported. The basic drugs like opium and things of that nature are imported, and therefore under the control of the federal government. There are some lesser ones, like marijuana and things like that, that grow in this country. In the exercise of its police power, the state may enact legislation concerning the filling of prescriptions and the sale of drugs. The state may also require the preservation of prescriptions and may further require their production for use as evidence in trials, not being privileged matter. Any time that a physician makes out a prescription for a patient, this is not a privileged matter. Any other thing that he may, in the treating of a case, diagnosis, and those things are privileged. But the use of drugs is one thing that is exempted from the privilege. In Eisenhower versus State, 157 Indiana, 517, it was held that the Drug Act was not unconstitutional as an unlawful delegation of power because it provided for determination by an administrative officer or a board of standards of purity essential to enforcement of the Act. The Pure Food Law provides that within 90 days after the passage of the Act, the Board of Health shall prepare regulations concerning and regulating minimum standards of food and drugs, defining specific adulterations. Now, this may not seem so important to you, but ordinarily, as I said before, any crime must be defined with sufficient certainty to be known by all, and the legislature must do this. But this, again, is one of those exempted fields where an administrative board is delegated the power to fix standards. In other words, the Board of Health fixes standards in food and drugs. And this is one of the rare instances and exemptions from the criminal law where the legislature does not itself define. The compounding, sale, and dispensation of drugs are subject to regulation by the state only to the extent necessary to protect the public health. Such legislation must not be arbitrary or capricious. The power of the state in this area is not restricted to drugs which are inherently dangerous but may be extended to patent and proprietary medicines. The word proprietary has been defined to be a medicine that has been compounded by a manufacturer according to his own formula, which may be alleged to be competitive with another preparation of the same sort. I'm sure that all of you have run into the proprietary drugs on the market, and I think John Brinkley down in the Southwest someplace is one of the fellows who made a fortune out of compounding his own drugs. In the further exercise of its police power, states may enact legislation forbidding the sale of poisons by druggists to any person unless he has satisfied himself that it is to be used for a legitimate purpose. And of course, some narcotics, or most narcotics, are within the definition of poisons by law. The Indiana Dangerous Drug Act, Chapter 45, Acts of 1961, defined prescription to be 1. A written order for dangerous drugs issued and signed by a practitioner authorized by law to issue a prescription, or 2. An oral order by a practitioner which is reduced promptly to writing by the pharmacist. And this occurs, of course, when you go to a doctor's office. He calls up the druggist and says, look, so-and-so will be down there in a few minutes. Give him a prescription, or the party will call from home to the doctor, and the doctor will call the druggist. But he must, by law, reduce that promptly to writing and keep that in file available to the proper authorities at any time. This act also defines dangerous drug to be 1. Any drug, the label of which is required by federal law to bear the statement, caution, federal law prohibits dispensing without a prescription. 2. When not subject to federal law, any drug which, because of its toxicity or other potentiality for harmful effect or method of its use or collateral measures necessary to its use, is not safe for use except under the supervision of a practitioner licensed by law to prescribe or administer such drug, or 3. A new drug which is limited by an effective application under state law to use under the professional supervision of a practitioner licensed by law to prescribe or administer such drug. The Acts of Indiana, Burns Indiana Statute 10-3501, provide that it shall be unlawful for any druggist or druggist clerk to sell, barter, trade, or give any opium, morphine, or cocaine to any person addicted to the habitual use of morphine, opium, or cocaine, unless such person secure a written prescription therefor from a licensed physician. I think only once in the, at least to my knowledge, around here, and it was not, again, a state case, but a federal case, has this law ever come into use. There was one druggist, to my knowledge, who lost his license through the unlawful sale of prescriptions or drugs without a written prescription therefor. Incidentally, most of these offenses come under federal law. We personally don't deal with too many of them. Once in a while we do, and but most of them are under federal law and under federal jurisdiction. A druggist is required to be licensed in order that he may be permitted to sell poisons of the kind above mentioned. In other words, opium, morphine, cocaine, or drugs of that nature. A registered physician who keeps a drugstore cannot sell the articles mentioned in this section except in pursuance of a prescription the same as any other druggist. In 1935, the legislature in Indiana passed the Uniform Narcotic Drug Act, which has been amended in certain respects by later legislatures. In it, it was enacted, shall be unlawful for any person to manufacture, possess, or have under his control, sell or prescribe, administer, dispense, compound, or use any narcotic drug or drugs except as authorized in the laws of the United States or of the state of Indiana, or for any person to be found in a public place under the influence of narcotic drugs. It further provides that no person shall manufacture, compound, mix, cultivate, grow, or by any other process produce or prepare narcotic drugs, and no person as a wholesaler shall supply the same without having first obtained a license so to do from the State Board of Pharmacy. The state has this right to regulate the practice of pharmacy so long as the laws are designed to ensure competence and diligence of the pharmacist, the purity of the products dispensed, the unlawful sale of narcotics, and other matters in the general protection of the health of the public. It has been held, however, that the state may not restrict ownership of drugstores to registered pharmacists. And this was held in 278 United States 105. In many states, however, laws have been enacted that require the sale and dispensing of drugs to be under the supervision of a registered pharmacist. The operation of such statutes is held to apply only to that part of the premises where the sale of drugs is actually going on. Of course, you see this every day in the chain drug stores, where in the drug section, which is separate and apart and must be so by law, there is a registered pharmacist in charge of that part of the business, and he has charge of every part of this. And the leading case on that was Noel versus People, 187 Illinois 587. In the general exercise of its police power, a state may regulate the administration, sale, prescription, possession, and use of narcotic drugs. And this was set out in Niswonger versus State, 179, Indiana 653. In this case, a police officer gave a state's witnesses money to buy cocaine from a physician who also held a license as a registered pharmacist. In other words, this doctor ran a drugstore. The witness purchased an 1/8 ounce of cocaine, the sale being made without a written prescription of a duly registered physician. And in this case, the doctor, as a druggist, sold the cocaine and didn't take the time to write out a prescription. If he was this man's doctor, he could have done so. If he was not, he could not legally do so. But in any event, he didn't even protect himself to that extent. The court held that the statute applied to all persons, and if a physician, although duly licensed, commits the act charged in the affidavit, he is not accepted in the operation of the law. The statute prohibits sale except under certain conditions, and there is nothing in the act which will authorize a physician to operate a drugstore and as such druggist to sell cocaine to anyone applying therefore without having a written prescription as provided by law. So when they operate in the dual role, then they must operate as a druggist. The Uniform Drug Act defines the term narcotic drug to mean coca leaves, opium, cannabis, and every substance neither chemically nor physically distinguishable from them, and any other drugs the importation, exportation, or possession of which is prohibited, regulated, or limited under the federal narcotic laws. Attempting to obtain a narcotic drug by fraud or concealment of a material fact or by use of a false or forged prescription, the affixing of a false or forged label to a package containing narcotics, and the making of a false statement in any prescription, order, report, or record required by the Act, possession of narcotics drugs is prohibited except as defined by the Act. State versus Reed, 34, New Jersey, 554. It was held that equal protection of the law is not denied by interpretation of the Uniform Drug Act so as to prohibit all unauthorized possession of a narcotic drug, including possession for eminent personal consumption not related to medical treatment, even though use of narcotics is made by statute a mere disorderly person's offense, since reasonable grounds exist for distinguishing between a possessor who can pass the drug on to others and a user. No exception is made as to possession of narcotics except for personal use. Some courts have held that the amount or quantity is not material to possession, but other courts have held the amount must be sufficient to be applied to the use commonly made of it. And there is a considerable difference of opinion between the 50 states about how much narcotics must be in possession to cause a criminal charge to be filed. Indiana follows the theory that any in possession not for imminent personal use is a violation of the Act. There are quite a few states who differ with that, but I think it's pretty well balanced. The Uniform Drug Act provides that one who has obtained a narcotic drug from a physician, a dentist, or a veterinarian for administration to a patient during the absence of the doctor must return the unused portion when it is no longer required by the patient. I seriously doubt that very many people ever do that. When you get drugs from a doctor, if there's any left, I seriously doubt that, or from a drugstore rather, that the unused portion is ever returned. I don't suppose anyone does that, but yet if you have an amount on hand which would induce an amount on hand which would cause a person to come under the influence of it, it would be a violation of the statute. In the prosecution for a violation of statutory provisions, the indictment or affidavit must state clearly and definitely all the essential elements of the offense charged. In the charge of making an unlawful sale, knowledge that the drugs sold were prohibited drugs need not be alleged, because knowledge is not an essential element of the offense, nor does the name of the purchaser need to be alleged. In other words, here is one criminal statute that is far different than most, in that the possession of narcotics, even though you may not know you have them, is unlawful. An indictment for obtaining drugs by fraud need not set out ownership of the drug, since the offense is not concerned with property interest as such. And again, who it belongs to makes no difference. The possessor is the person who has violated the law. Entrapment is frequently raised as a defense to a charge of violation of the Drug Act. The defense may not be successful if it be shown that at the time the defendant was engaged in a course of similar crimes or had formed an intent to commit similar crimes. If it be shown that the criminal intent did not originate in the mind of the accused, but in the mind of the enforcement officer, and the accused was lured into commission of the offense by persuasion, deceitful representation, or other inducement, the defendant may not be convicted of any offense. Entrapment is a positive defense, and the burden of proof is on the defendant. It may not be used if the accused denies the offense. The term burden of proof, maybe you're not familiar with that, but in all lawsuits, whether it be civil, criminal, whatever it may be, there is set out by our rules of evidence and rules of procedure the burden on this party to establish this part, or the burden on the other party to establish something either in defense or mitigation or whatever. Ordinarily, in all criminal charges, there is a burden on the state to prove the essential elements of the crime charged, and if the state fails to prove that, then the defendant is entitled to an acquittal at the end of the state's testimony. Entrapment, however, is a positive defense, and the defendant, if he alleges entrapment or uses that as a defense, then he must prove entrapment, and the burden is not on the state to do that. Insanity is also another positive defense, and it is up to the defendant to prove that at the time of the act that he was under the influence of drug, and we'll get into that later. The general rules of evidence apply in the prosecution of drug and narcotic offenses. This is true. Generally, all the rules of evidence do apply. There are some exceptions to that, however. The court may take judicial notice of the evils of narcotic traffic and of legislative intent to repress such evils in the penal statutes. Now, judicial notice, again, this may not mean anything to some of you. Judicial notice is that state of affairs that a court will take notice of without proof by either side. Some things are judicially noticed. I know one time I was trying a case and I had to get away for a luncheon appointment, and it was 20 minutes till 12, and I had to be there at 12, and so I took judicial notice that the time was 12 o'clock and adjourned court, even though it was only 20 minutes till 12. Now, that's one thing that you can notice. Now, that's on the rather odd side, but frankly, there are things that a court can take notice of. For instance, that Muncie, Indiana, is a city incorporated in the state of Indiana, and we can even take notice of its populations. We cannot, however, take notice of its laws. There are some real quirks in judicial notice laws. We do take judicial notice of all the laws of the state of Indiana and the laws of the United States. We do not, however, take judicial notice of the laws of any town or city, and those must be proven. In other words, if someone comes into my court charged with speeding, violation of the ordinances of the city of Muncie, the burden is on the state to prove the municipal statute that has been violated. Of course, speeding comes under generally the state statutes, but if there is a peculiar statute in the city of Muncie that is not generally under the speed laws of the state, then the state must prove that statute in order to obtain the conviction. And this is what I mean by judicial notice. There are some things that courts do take notice of. We take notice of the statistics of the United States Chamber of Commerce, for instance, of populations and things like that. This is sort of sideline, but you might not know what judicial notice would be, so I thought I would explain that. So the court may take judicial notice of the evils of narcotic traffic. And this is going pretty far out when the United States Supreme Court said that, but they have held us to be so we do take notice of it and apply it in the enforcement. And also the legislative intent to repress such evils by enacting penal statutes. The state must prove every other essential element of the offense charged. On a charge of possession, proof of constructive possession is sufficient. In such prosecutions, one who is prosecuted has the burden of showing that he is within one of the exceptions of the Act. In other words, a mere proof of possession shifts the burden to him, whether it be constructive or actual, shifts the burden to him of proving that he is within one of the exceptions in having it. In a prosecution for illegal importation of narcotic drugs under a statute making the unexplained possession of illegally imported drugs sufficient for a conviction, the burden of identifying the legitimate source of drugs alleged to be illegally imported shifts to the defendant. And this is set out in Hernandez versus United States, 300 Federal 2nd, page 114. In any action filed, it is not necessary to negative any exception, excuse, proviso, or exception, and a conviction or acquittal under the federal law for the same act or omission is a bar to a prosecution by a state court. In other words, if there are two statutes, one federal and one state, and the person is prosecuted by the federal, then that's a bar to a prosecution by a state court. And vice versa. If the state acts first and prosecutes, then the federal government is prohibited from prosecuting. Where a physician was prosecuted, his lack of good faith was sufficiently established by proof, among other things, that he told the buyer that she could sell some of the drugs to purchase more morphine. The same case held that the mere fact that narcotics agents furnished money to the person who made the purchase did not entitle the defendant to an acquittal under the theory of entrapment. In 1939, the legislature passed a law concerning destruction and eradication of marijuana weeds. Set out that every person, firm, or corporation owning any real estate in the state of Indiana, or any occupant of or tenant leasing or living on such real estate shall hereafter be required to destroy and eradicate all weeds of the plant Cannabis sativa, commonly known as marijuana, Indian or wild hemp, or local weed found growing in such real estate as provided in this Act, provided, however, that the provisions of this Act shall not apply to any person, firm, or corporation that obtains a license for the cultivating and growing of said plant Cannabis sativa in accordance with the laws of this state or of the United States. Incidentally, I noticed in the paper this morning where two Chicago boys were picked up for harvesting marijuana up in the northern Indiana, one of the northern Indiana roads yesterday. So they were in violation of this Act, I suppose. Whenever any owner, lessee, agent, or tenant having charge of such real estate is notified in writing by any federal, state, county, or municipal officer whose duty it is to enforce the narcotic laws of this state or of the United States that there are marijuana weeds growing in such real estate, such owner, lessee, agent, or tenant shall proceed to destroy and eradicate said weeds. This makes the violation to grow it for anyone to do so.